Good afternoon. Thank you all for being here. Continue to enjoy your lunch. I'm Reg Brown. I was running a little behind this morning and was very worried about finishing my welcoming remarks. So I did what every young lawyer in this room would likely do. I asked ChatGPT for help. So the remarks that follow are totally unedited, and you can decide for yourself whether ChatGPT is woke or not. You might be surprised. Good afternoon, everyone. On behalf of the Federalist Society, I'm honored to welcome you to today's luncheon. It's great to see so many members of the bench and bar, students, scholars, practitioners, all gathered to reflect on another historic Supreme Court term. Now, before we begin, I want to offer a warm welcome not just to our members and guests, but also in spirit to the many commentators out there who are convinced that the Federalist Society is the secret puppet master behind every major legal development in America. Apparently, if you read enough Twitter threads, or as they're now called, legal scholarship, we're not just a network of lawyers who care about originalism. We're kind of a constitutional Illuminati, if only it were true. Frankly, if we had even half the power our critics think we do, we wouldn't still be eating chicken for lunch. What we do have, what truly binds this group together, is a shared belief in constitutional government, that the meaning of legal text matters, that liberty depends on structural limits, and that judges should say what the law is, not what they wish it to be. This term has given us plenty to analyze: questions of executive authority, religious liberty, administrative overreach, and the proper role of the courts. The stakes are high, and so is the standard of legal argument needed to meet them. Which brings us to today's featured guests, two people who know these issues firsthand and who bring both brilliance and principle to the table. Kristen Waggoner, CEO, President, and General Counsel of Alliance Defending Freedom, continues to lead the charge in some of the most consequential cases of our time, including a key victory this term. Shanmugam, managing partner at William & Connolly and one of the most respected Supreme Court advocates in the country, has argued more than 30 cases before the court. And this is the point at which I decided maybe I shouldn't use ChatGPT because it has this thing called hallucinations. So with apologies to Kannon and Paul Weiss. I will say, though, that the rest of that was pretty good, and one might even be tempted to think that ChatGPT is in on the conspiracy, and that maybe it knows something about Kannon's future that not even he does. Seriously, though, I want to thank Kristen and Kannon for being here. ADF is an extraordinary and impactful law firm, 450 staff members in 10 offices worldwide, leading roles in some of the most consequential decisions of our lifetimes, including Dobbs, cases in every one of the last 13 terms and 4 in the upcoming term, and a record that goes beyond the court, including amazing work to secure the release of more than 2,000 individuals who were wrongfully imprisoned because of their faith. Kannon is, of course, beyond the need for an introduction. He leads the Washington office of Paul Weiss and is one of the nation's most accomplished appellate lawyers. He's argued 39 cases before the Supreme Court and appeals in all 13 federal courts of appeal. He was also the lead lawyer in a landmark case that invalidated the structure of the dreaded CFPB. As I invite Kannon and Kristen to the stage, I'd be remiss if I didn't close with a non-AI generated comment about the late Ted Olson, who for many, many years made this event his own, and the event not to miss every summer. Ted was a man of extraordinary character and brilliance and courage, and I'd like to think he's looking down on us today, feeling very proud that his event is in the care of these two very special advocates. With that, I give you Kannon and Kristen.
All right. First of all, I just want to say that when I think of the Wilmer Hale Law Firm, I think of Reg Brown. So, sorry, too soon, I know. It is just such an honor to be here, and in particular to be here with someone who I have so much admiration and affection for in Kristen, Waggoner. And I just want to start by echoing where Reg left off. I, as a young lawyer, came to this event for many years when Ted Olson did it. It was really a highlight of the summer every year. And if you had told me then that I would be doing this now, I would never have believed you. So it is just an incredible honor to be invited to talk with you about the Supreme Court today.
It is an honor for me as well, but also to join with you. The number of Supreme Court roundups that I've listened to you do in the past is too many to count. So I'm happy to ride on your coattails today and take your lead. As we begin, we are going to be talking, we've selected about 12 cases to talk about, including cases on the emergency docket. Those cases will range from anything from immigration to guns to, of course, universal injunctions, to LGBT issues, defunding Planned Parenthood, you name it, we've got it covered. Some would say it wasn't necessarily a consequential docket in terms of blockbusters, but I think if you look at it in terms of the breadth of subjects covered, it is quite significant. Before we start though, my initial task is going to be to talk a little bit about the numbers. And we all can look up the stat pack from SCOTUS blog, and many of those numbers have come from there as well as the New York Times. But I'm going to start with the numbers, and then Kannon's going to take over with some of the trends, and then we'll discuss those together before we hit the cases. In terms of the numbers, as you may have seen, the court took, in terms of majority decisions that were signed and were argued, there were 56 this year, and the Times has reported that that's the least that we've seen since the 1930s. At the same time, we're looking at the emergency docket, and we cannot keep up. I don't know about you, but I was getting emails last night about what was happening on the emergency docket, and then this morning again. So we know that a significant portion of the court's time is spent on dealing with those issues. It might be helpful if the district courts would stop with those universal injunctions. In terms of where we're at on writing, there was a lot of writing that went on this year in concurrences. The dissents were about average. What we've seen is they stated about 48, but the number of concurrences remains high at 50. And Justice Thomas set the record with 29 this term in those concurrences. Also, I would remind you that we have those concurrences, or justices often use those concurrences to move the law forward, to seed the ground. And one of my favorite things to do is to actually read those decisions to see what the court's thinking about the next cases to come. And there's certainly a number of teasing moments in those this term, particularly in Schermetti. One of the things that I thought was significant, though, was that this term the Chief Justice did not write any dissents at all, and that the rate of unanimous decisions was actually normal. 42%. Last year was 44%. So despite what our leftist progressive friends want to think, actually the court is not quite as partisan as they might want to represent to the rest of the world. What we have seen as well is that there were 11 decisions in all of the 56 decisions. 11 were 6-3 this year. And the winners in terms of the majority. The big winners were the Chief Justice and Justice Kavanaugh. I bet most of you could have predicted that with a 95% and 92% rate. Justice Barrett was third, and you may not know this, but the real winner was Justice Kagan in a strong fourth pole position, and she's always the one to watch. And in fact, of her 6 decisions, one of the things that surprised me was 5 of them were unanimous decisions that she wrote this term. So, when we move to the clearly divided cases, I think another thing that's important to point out is that in closely divided cases, Chief Justice was also the winner in those cases, and Justice Kavanaugh was next there as well, so no surprises. And in terms of good friends, good buddies on the court, we can probably guess who those were. Of course, it is this year the Justice Thomas and Justice Alito, as well as Justice Sotomayor and Justice Jackson. Those are the best friends on the court. And what the stats also tell us is that Justice Gorsuch needs a friend. He wrote solo more than any other justice, and what we do see is there's a high rate of agreement with at least 2 to 3 justices on the court, but Justice Gorsuch is down there near 80%, having some independent thought. We know he stands up for the bullies and the little guys, and from what I read, Justice Barrett is actually most often on the side of the government, which we probably need to let the Trump administration know that. Lastly, as we're thinking about these divided ideological issues, I do think it's important to recognize in the 6-3 cases where the lines fell, because they did not fall on partisan ideological lines predominantly. In fact, the 3 conservative justices were in dissents as much as the 3 liberal justices at 15%. And that's a little known fact that I think we would all do well to be evangelists on in our world. Also, in terms of those percentages, the justices were ideologically split in predictable ways less than 10% of the time. And I know some will say, well, that's simply because there are less than 10% of the cases that are the blockbuster cases. But I was startled to see when we picked those 12 cases to talk about, a number of them were 9-0 decisions. In fact, 5 are 9-0 decisions that we're going to talk about today. So that's a little bit about the stats, and now Cannon's going to talk for a minute on the trends.
Great. Well, I'm going to be Tony Romo to Kristen's Jim Nance here and just offer a couple of color commentaries on those statistics. And there are really 3 developments that I want to highlight. The first is the rise of the emergency docket. You know, when I was a law clerk up at the Supreme Court now almost exactly a quarter century ago, the emergency docket basically consisted of last-minute stay applications from people on death row. Obviously now the emergency docket has taken center stage as the place where initiatives by administrations are litigated and in some circumstances basically adjudicated. And there are a lot of reasons for this growth, but I think that the biggest reason in some sense is the disappearance of Congress from the scene, and we have seen presidents of both parties now resorting to unilateral action in the form of executive actions or regulations in order to implement their policy priorities. And that leads to the predictable cycle where presidents take these actions, their opponents bring suit, often in handpicked forums. They obtain injunctions, more on which in a moment, and these issues get up to the Supreme Court because particularly if major policy initiatives are enjoined, presidents are going to take those issues all the way up to the court. And the numbers are startling. If you go back to George W. Bush in 8 years in office, he sought emergency relief from the Supreme Court 5 times, President Obama 3 times in 8 years. And then in Trump 1, the first Trump term, there were 41 such applications. There were 19 in President Biden's term. And now in the second Trump term, there have been 20 already. And so that is a really remarkable change, and it's occurred across administrations. The Trump administration has largely been successful. It is now, as of this morning, 16 of 18 in applications that have been adjudicated, and we're going to talk about that more in a minute. The second trend I want to highlight is the shrinking of the traditional merits docket. And while it may seem like the court is writing longer and more opinions in the cases it hears, as Kristen pointed out, it's simply hearing fewer cases. It was hearing about 80 cases a year when I was a law clerk 25 years ago. Over time, that sort of dwindled down to 70. During the pandemic, it went from 70 to about 60. And this year, by my count, we got 56 merits opinions from the court. And what is, I think, particularly striking is the almost complete disappearance of certain types of cases from the court's docket, and that is particularly noticeable for those of us in private practice on the court's business docket, where substantive rulings in areas of the law like securities litigation, antitrust, patent litigation have all but disappeared. And in the few cases that the court hears, often the court is dismissing those cases as improvidently granted or reaching very narrow rulings, which can often be a real source of frustration for litigants and lower courts alike. And then the third trend I do want to highlight, and we will come back to this in the context of particular cases, is the emerging center of the court. You would never believe this if you got all of your Supreme Court news from the New York Times, but the reality is that three justices, the Chief Justice, Justice Kavanaugh, and Justice Barrett, really are emerging as the center of the current court. And as Kristen pointed out, they were the three justices who were in the majority the most often this year. In fact, if you look at the statistics, as the New York Times did highlight, Justice Kavanaugh has been in the majority more during his 7 years on the court than any other justice, as long as records have been kept going back to the 1950s. And I think what is really striking is that if you look at the 6-3 cases, I counted 10, but I think that that's because there were a couple that were consolidated. In all 10 of those cases, those three justices were in the majority. In 6 of those cases, they joined the other Republican appointees on the court in the majority. In 4 of those cases, they joined the Democratic appointees in the majority. And so I think that that really illustrates how, as Sarah Isgur is fond of saying, we really have a 3-3-3 court nowadays. And again, I think that that is something that has taken place for long enough now that we can say that that really is a trend.
Absolutely. So as we shift to the emergency docket, my kind of favorite case personally is the CASA case, because I think it's fascinating about where it is going and Justice Kavanaugh's concurrence. So tell us about that, and will you start us off on the emergency docket?
Yeah, I'm going to start off with the emergency docket, and I'm really going to highlight, I'll say 3 cases, and I'll try to do this quickly so that we can talk more generally about what's going on with the emergency docket. But the case that probably got the most attention this year was Trump versus CASA. It was an interesting case because it was one of these cases that came up on the emergency docket, and the court sort of moved it to its merits docket. The court heard oral argument, but somewhat oddly did not receive additional briefing before the oral argument, so it was kind of a quasi-merits case by the time it was all said and done. This is the case involving the challenges to the president's executive order banning birthright citizenship. You had district courts, 3 district courts, entering essentially nationwide injunctions against that executive order. And perhaps not accidentally, the administration sought review not on the underlying merits of those determinations, but instead on the procedural question of whether federal courts have the power to enter these nationwide injunctions. What did the court do? Well, what the court said was that federal courts have the power to grant complete relief to the parties in front of them, but not the power to grant universal relief to everyone who is potentially affected by the potentially unlawful act that is being challenged. And the court sent these cases back to the lower courts to essentially sort out how broad of an injunction was necessary to satisfy that requirement. Now, one thing that was interesting in this case is that the Chief Justice assigned the opinion to Justice Barrett. She wrote a very learned opinion in which she went through the history of courts at equity, applying the reasoning of a case called Grupo Mexicano, which was perhaps not coincidentally decided in an opinion written by Justice Scalia the year that Justice Barrett clerked for him. And it is a very important opinion on the scope of equitable power of the federal courts. I think the thing that had everyone a Twitter, no pun intended, after this decision was the back and forth between Justice Barrett and Justice Jackson in particular. Justice Jackson wrote a solo dissenting opinion that I think was notable for its strident tone, in which she accused the majority of putting both our legal system and our system of government in grave jeopardy. Those are fighting words by Supreme Court standards, and it provoked a sort of equally stern response from Justice Barrett, who said, and I'm quoting, that Justice Jackson chooses a startling line of attack that is tethered neither to legal sources nor, frankly, to any doctrine whatsoever. We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. We observe only this: Justice Jackson decries an imperial executive while embracing an imperial judiciary. Now, I think that this was really quite fascinating because this was definitely a sort of Supreme Court throwdown. And a friend of mine pointed out that in some sense, I think the source of this might have been Trump versus Anderson, which you may recall was a case involving the challenge to President Trump being on the ballot, where Justice Barrett wrote a concurring opinion that called out the dissenters that said, and I'm quoting, "This is not the time to amplify disagreement with stridency. The court has settled a politically charged issue in the volatile season of a presidential election. Particularly in this circumstance, writings on the court should turn the national temperature down, not up." And I think in light of that, it's hard not to view this back and forth as Justice Barrett, I think, being concerned about this sort of strident rhetoric that really called the good faith of the majority into question. Now, to me, what I think is most interesting about all of this is, notwithstanding the amount of attention that this decision got, I think it may actually end up having fairly limited practical consequences. And that is because the court, both in this case and in an earlier emergency application case, a case called AARP, has indicated that one way in which district courts can grant broad relief is by exercising their power to grant temporary relief to a putative class. In other words, that if a court thinks that a class action might eventually be certified, presumably by engaging in some sort of quick look at whether or not this feels like and quacks like a class action, the court can then proceed to grant nationwide relief. And you might wonder where that authority comes from. In the AARP case, the court cited, and this was the sole authority the court cited, Rubinstein on class actions. I guess that's the next best thing to the Constitution when it comes to the power of the federal courts. But yet the court made quite clear that this was permissible. And lo and behold, when these cases on the birthright citizenship ban went back, one district court in New Hampshire has already entered exactly the same injunction on precisely that ground, on the ground that you could certify a class of individuals who are no longer going to receive citizenship as a result of this order. And if the Supreme Court countenances that practice, I think that the practical effect of this decision is going to be quite modest, because there will just be this additional step that courts have to take. And I think that that may have been in part because what bothered the court about this was the notion that states could seek these injunctions even in contexts where it is clear that a different group of states might have a completely different view. And if that was what was animating this, I think what the court is basically saying is you've got to find a real plaintiff first, and then you've got to have a plaintiff who has a generalizable injury. But once you do that, it's off to the races. You're going to be able to get a very broad nationwide or universal injunction, and that will present all of the same litigation challenges. Let me just briefly cover the other two cases on the emergency docket that are significant. I personally think that the case that's going to have the most lasting significance is not the CASA case, but instead Trump versus Wilcox. And this is the case involving the issue that in a very real sense is a sequel to the Sale of Law case that I argued. This is the question of whether the president has the power to remove the members of multi-member commissions like the SEC, the NLRB, the Merit Systems Protection Board, and the like. And President Trump, since taking office, has pretty systematically sought to remove the Democratic members of various commissions. The Wilcox case involved the NLRB and the Merit Systems Protection Board. And the question that came before the Supreme Court on an emergency application was whether the president has the power to do that without cause. And the Supreme Court said the answer to that question was likely yes, relying on some language in the Sale of Law opinion that indicated that the principle that the president has the power to remove federal officers is subject to a very narrow exception, the so-called Humphrey's executor exception, which the court said in Sale of Law applies only to agencies that do not wield substantial executive power. And the court in this case basically signaled that for agencies like the NLRB and the MSPB, that those agencies are likely not to fall within that exception, and therefore that the president was entitled to remove, at least temporarily, these officials. Now, Justice Kagan, who was the dissenter in Sala, dissented here, and she said that the court was effectively overruling Humphrey's executor. I think with respect that that's not quite right. I think that to the extent that the court was doing that, it did that in Sale of Law, and I think in some sense Justice Kagan is fighting a battle that she lost 5 years ago in Sale of Law in that regard. But just yesterday, in the case that Kristen referred to, Trump versus Boyle, the court doubled down on that. It once again held that the president has the power to remove commissioners, this time in the case of the Consumer Product Safety Commission. And what I think the court is basically doing is signaling that it has basically already decided this issue, or certainly come very close to having decided it, and I think that's why the court did it on the emergency docket. One footnote, the court distinguished the Federal Reserve, which was the example that had been held up by the removed officials as kind of the example as to why you might say that the president doesn't have this power. And the court distinguished the Federal Reserve on the constitutionally grounded principle that the Federal Reserve is a, quote, uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. And so if you can find that in your copy of the Constitution, please let me know. But what that means is that if the president wants to remove Jay Powell, he's going to have to concoct a cause for doing so. Final cases, I just want to mention AARP versus Trump and Department of Homeland Security versus DVD. These are the cases involving immigration. And I think what we're seeing in this area is the court applying at least some degree of brakes on the administration. But it remains to be seen how that's all going to cash out. In the AARP case, which caused heart palpitations at the organization that is the AARP, because those were the initials of an immigrant who would have known that there was somebody with the initials AARP. The court essentially enjoined the removal of members of a Venezuelan gang without giving them first notice and the opportunity to be heard before their removal, pending proceedings on remand before the Fifth Circuit. And that case has now been argued in the Fifth Circuit on remand. This was notably over a dissent from Justices Alito and Thomas. And I think that what the court was doing there was essentially maintaining the status quo pending a resolution of how much notice is required and whether notice is in fact required at all. And in the DVD case, another interesting set of initials for those of us of a certain age, the court stayed an injunction on behalf of a putative class of so-called third country removals. So this was individuals who were being removed to not their countries of origin, but to other countries such as South Sudan. And that led to this very peculiar set of proceedings where the district court, which had enjoined the removal that the Supreme Court had then stayed, sought to enforce a remedial order that was based on the earlier injunction. The government sought clarification that that remedial order was no longer in effect, and the court said you can't enforce an order that is based on an underlying order that has since been stayed. That led Justice Sotomayor to say that other litigants must follow the rules, but the administration has the Supreme Court on speed dial. And for those of you under the age of 40, speed dial was once a thing. So
now it's just favorites.
Yes,
favorites.
Exactly. So Kristen and Reg and I will explain it to you afterwards. So the bottom line is that I think that the government has broad authority in the context of immigration, but it's not untrammeled. And I personally think it's hard not to conclude that the court was a little bit disquieted by the administration's attacks on district courts in this context. And it had some desire to kind of protect the judiciary and to ensure that the judiciary has a say before removals take place. And so this was one area in which the administration did not prevail.
So before we move to the merits cases, I think one of the things that's always helpful, especially when we've already had our lunch, is to say, why does this matter? What are we looking forward to in the future? What might this mean? And sort of trying to read the tea leaves. And I think from my perspective, when I think about those cases, a couple of things come to mind in the areas that we work in. One is I feel like the court is kind of talking a little bit less about, or a little bit more about associational standing, but wanting to see a little bit less of it. And sort of reining that back in. And what does that mean? And certainly the CASA decision talked about that. In addition to that, when do states have standing? Again, I think the court is really grappling with that, and I say this with much charity in my heart. In many ways, it has felt a little bit schizophrenic on it over the course of the years. When you look at what the court had to say in Little Sisters versus what some of the things we're seeing now, and when will those states have the standing that is required to move forward? And lastly, I just have to say on the emergency docket, so many of these decisions I probably would read, maybe on vacation, but instead I've read them this week, but I don't have to read them for my work specifically. But what I came away from even those decisions with was Justice Kavanaugh's ready to go get them. I mean, in so many of these decisions, he's saying, let's go, let's grant this, let's decide this. What do you make of that? Given that I've always thought of him previously as being somewhat reserved and kind of still getting his footing, and maybe he'd be not the front of the line to say, let's decide this.
I think Justice Kavanaugh is the only member of the court who wants to hear more cases right now. And just yesterday in the CPSC case, he said, let's grant cert before judgment. I think he would probably hear oral argument in August if he had his way. And so I don't really know what to make of that, except that, I think that he is someone who really understands the need for lower courts and litigants to have clarity. That's something that he often talks about. And I suspect that he probably would prefer a world in which the court was deciding more cases and perhaps writing a little bit less, though he's one of those justices who is prone to separate writing in cases. But he doesn't seem to have a lot of pals in that regard.
Well, I'm hoping he can get some soon.
Well, we're done with lunch, so shall we talk about religion and guns?
Religion? Yes, religion and guns. Guns aren't necessarily my forte, but religion is.
All right, I'll take guns.
Well, I will start with religion, and that has to do with Mahmoud. So we're going to talk for a minute. I'm going to actually address the First Amendment in general, those cases. So we'll go through Mahmoud, Catholic charities, as well as free speech, and then have a little interchange on the First Amendment cases. And so it's a bit of a flyby, but in the Mahmoud case, what we found in the Mahmoud case was it was a question of parental rights, but it was parental rights in the context of the Free Exercise Clause. Justice Alito wrote the majority decision. It was a 6-3 decision, and from my personal perspective, he did a great job writing that decision. When the court went there, it tended to go there in a pretty big way, and this was one of those cases. If you're familiar with the precedent that's involving public school curriculum or the rights of parents in public schools, we kind of lost that battle quite a few years ago, in a number of terms ago. And coming back up to, again, assert the rights of parents in public schools has been an uphill battle. So we're thrilled that our friends at Beckett were able to prevail in this case. The facts are quite egregious, though. So when you look at the facts of this particular case, it's Montgomery County in Maryland, a very diverse religious community. Essentially, there were 5 books that were at issue in the K through 5th grade curriculum. The school basically said, not only are we going to put these books on the shelves, but we are going to encourage teachers to read them and to adopt them and integrate them into their curriculum. The school also instructed teachers to essentially tell a child that might question what the message was in the book, that not just maybe that this thing exists, whether it's gay marriage or it is a boy identifying as a girl, not just to say that happens, but to actually tell them that to disagree with it is hurtful and that these things are to be celebrated. And so the court essentially said, this is a bridge too far. Coercion is not the standard. There can be more subtle burdens, and it went for Yoder. So I liken this case to make Yoder great again. And the court did. It did it in a phenomenal way in saying that when there is a substantial burden on the rights of parents to direct the religious upbringing of their children, that is a bridge too far, and it violates the Free Exercise Clause. I do want to say, though, as we think about the facts, because I think if you read the dissent, you don't really know what happened in the case. And it, as Justice Alito said, it airbrushes the record somewhat of what was really going on in the public school system. Some examples that you might find interesting in this. First of all, the school conceded that the purpose of the books was to disrupt the children's thinking. That's according to them. In putting these books in the classroom, the school was supposed to ask whether heteronormativity, cisnormativity, and power hierarchies, you can look those terms up later, were essentially to be reinforced or disrupted. And you know which way that goes. And it also made a number of hostile comments at board meetings about the parents in sort of a masterpiece-esque way, including even to a student that suggested she had bought the dogma of her parents. So this is all in the record. In addition, I would just say, as we move past Mahmood to have further discussion, the court applied strict scrutiny. But I think what's very interesting about this was there were a number of ways that the court could have resolved the case, and yet it chose to go back to Yoder and say, we're not breezing by this precedent anymore, we're breathing new life into it. And I believe that new life will help millions of families in the future. But the contours of it is something we really are going to have to talk about and work through. In terms of the next case, Catholic Charities, that was a unanimous decision, and the Catholic Charities case was written by Justice Sotomayor. Justice Thomas wrote a concurrence as well. In the Catholic Charities case, the diocese of the certain area, the geographical area, essentially had a social arm, and in that social arm was the Catholic Bureau, and that Catholic Bureau was responsible for doing the good works of the church in certain areas. In the Wisconsin unemployment statutes, they essentially said we're going to carve out some exemptions for religious organizations. That's a very common exemption that you'll see in state law. And as that exemption was being meted out by the Wisconsin Supreme Court, which took over a decade or nearly a decade, they started narrowing that in a way that only a court could and a legislature probably didn't intend it. The way that it narrowed it was first to say, is this a religious organization? And they said, check mark, yes, because it's supervised by the diocese. But then it went to the second piece of it and said, we're going to look at the motivations and the activities of the Catholic Bureau. And in doing that, they said, worship is in, sacraments are in, helping the poor, that's out. That's not sufficient. If you are a religion that believes that you don't have to proselytize when you're doing that good work. So. Now, you might say, well, just be easier, the Catholic Church should change its doctrine. No, Catholic Church shouldn't change its doctrine. What the Catholic Church's doctrine is that proselytizing, according to the court's record, proselytizing and doing social work isn't necessarily one and the same. And in part, you sort of are able to minister to the poor because you're motivated by your faith. The court said in this case that it's essentially discrimination among religions to separate it based on those things. And the court struck it down on the basis of that. And in that way, it sort of breathed even more life into a case called Larson. And Larson is a case that we've seen come into play in many different areas. What we can see is that it seems like if you're getting the more liberal justices on board with the court, you probably need, they're going to look towards more an establishment clause route than a free exercise route to sort of not give more teeth to the free exercise clause. I will also say that I think what's significant and interesting for future cases in this is that the executive director of the Bureau was not a priest, and they also were ministering to individuals who were not Catholic, and not all of their employees were also of the same faith, and yet the court unanimously said, no, you don't get to parse between who's religious enough under the Constitution, and that's a win for all denominations and all religions. Lastly, I'll talk for a minute about Free Speech Coalition, which I am guessing that we have a number of people that, if we raised our hands, we might disagree on some of the issues in the Free Speech Coalition case. And in that respect, I think that it's an interesting way that the court got to the decision that it did. In Free Speech Coalition, Justice Thomas wrote that decision. It was a 6-3 decision, and Justice Kagan dissented. Essentially what Justice Thomas said in the decision is, we know we have these content-based and content-neutral categories when we're determining what we're going to establish in terms of tiers of scrutiny. And in a content-based category, that means that essentially speech is targeted based on the message of the speech or based on the content. It's hard to say that this is not a content-based law when the whole purpose of the law is to ensure that minors don't have access to hardcore pornography. So it was a content-based law. But the court said in a content-based law situation where the speech is actually unprotected as to a category, think like defamation as an example, or fraud, those things are unprotected, then it's only an incidental burden on speech to put in an age verification requirement so that adults who want to access that and have a right to have to essentially put in some sort of age verification or meet those requirements. So it was a very interesting way of getting there, I thought. And essentially, the lower court applied strict scrutiny. The Fifth Circuit applied rational basis. The court said, no, I think strict scrutiny is too hot, and I think rational basis is just a little too cold, so let's just go to just the right temperature of intermediate scrutiny. And so that was very interesting to see how the court got there. So do you want to tell me your reactions to those things?
I actually have two reactions to all of this. The first is to wonder whether employment division versus Smith is going to be the Bivens of the First Amendment, and it's going to apply only to plaintiffs named Smith going forward, because it was really striking how the court breathed new life into Yoder in the decision in Mahmoud. And I think that was in some ways perhaps the most significant doctrinal development under the First Amendment this term. My second observation is that as an Episcopalian, I'm very glad that proselytization is not required, or we would never qualify for any exemptions. So we're just, we're far too restrained in our faith. I will make one serious observation, which is that in these First Amendment cases, and particularly the religion cases, I think the facts really matter, and the facts of what took place in Montgomery County in the Mahmoud case were really quite disturbing. And I think it's actually really a testament to groups like ADF and Beckett that they pick their cases with such care, because that really gets borne out in the way that these cases are decided. And you saw the extent to which the majority in Mahmoud really took advantage of the factual context in reaching its decision.
And I would just say that on the Mahmoud case, I think it was an opt-out, right? So the parents can opt their children out. The school tried to say, well, first of all, just pull your kids out of the school altogether. And Justice Alito said, no, you can't put that kind of unconstitutional condition. Then Justice Sotomayor said, well, it's the democratic process, right? That's how we determine what the curriculum is. And Justice Alito said, no, there's actually something called the Bill of Rights, and that's important. But I think in terms of an opt-out, it is important for us to think about the fact that we are celebrating a decision that says you get an opt-out when your children are being indoctrinated into particular ideologies. That is the bottom line of that decision. And I think that's important for us to grapple with that, in that some of the follow-up cases are going to be involving secret transition cases. There are dozens of secret transition cases around the nation right now, including one of our cert petitions was just filed in a case called Foote out of Massachusetts on Friday, where despite multiple requests by the parents, public schools secretly transitioned a child in that system. And they are not religious, but they do object. So what the breadth is of Mahmoud will be significant as we move forward, especially for parents who may not have younger children, they may have older children, and for parents who may not be religious.
The court left a lot of questions for the lower courts to work out in that decision. Well, shall I turn to guns? This will be a short segment because there's not much to report when it comes at least to the Second Amendment. So there were no Second Amendment cases on the court's docket in this year after the Rahimi case, in which the court seemingly stepped back from its change in Second Amendment methodology in Bruin. There are just two cases that I want to mention quickly. The first, Bondi versus Vanderstock, which was the case concerning the regulation implementing the Gun Control Act of 1968. That's the principal federal statute governing licensing, background checks, and the like for those who trade in firearms. This case concerned the validity of a Biden-era ATF regulation that took a pretty expansive view of the term firearm. It reached both weapons parts kits and partially complete frames and receivers. The court upheld the regulation as consistent with the Gun Control Act. This was a case that was actually argued before the election, but interestingly, the Trump SG's office did not flip the position. And it was kind of an odd case because the court largely dodged the question by saying that the appropriate frame, again, no pun intended, is whether the regulations in question were facially invalid, which, in the court's view, turned on the question of whether or not one can posit at least some example covered by the regulations that would fall within the scope of the statutory definition. And this was a 7-2 decision with only Justices Thomas and Alito in dissent. And both of them really raised, I think, some pretty serious questions about whether this methodology for facial challenges makes sense in the context of a challenge to a regulatory definition under the APA. And in some sense, this was kind of the mother of all punts by the Supreme Court, because the court really left open the opportunity for parties to bring as-applied challenges in contexts where the application to their facts seemed to fall within the outside the scope of the statute. And so it was, I think, a relatively narrow decision, but we'll see how this methodology for facial challenges plays out in future cases.
It is an interesting example, though, of how they deferred in one particular instance to an agency and their interpretation.
That's
so it's
right.
not all Loper Bright.
Yeah, and one thing, we'll turn to this briefly at the end. One thing that was really striking is that in the term after Loper Bright, you didn't see a lot of sort of skepticism toward the government when it came to issues of deference. And the Vanderstock case was perhaps the signal example of that. The other case, not surprising, Smith & Wesson Brands versus Mexico. This was a case involving the Protection of Lawful Commerce in Arms Act, which is a statute that provides pretty broad immunity to gun manufacturers for civil liability for gun use. And there is a narrow exception in that law for cases in which manufacturers knowingly violate federal or state law. And the government of Mexico sued several major American gun manufacturers, and they alleged that those companies aided and abetted unlawful gun sales that routed guns to Mexican drug cartels. The First Circuit permitted this suit to go forward, notwithstanding the broad immunity in this federal statute, and it was perhaps no surprise that the Supreme Court shut that down in a unanimous opinion written by Justice Kagan, a pretty fact-bound opinion that just said, look, this complaint does not plausibly allege aiding and abetting by the gun manufacturers, and therefore does not plausibly allege a violation of federal or state law. I think this is one area in which we should be keeping an eye out for upcoming cases, because there are many cases in the pipeline that present significant Second Amendment issues. There are the cases involving bans on AR-15s, the cases involving bans on large capacity magazine cases. There are the bans on 18 to 20-year-olds, the states that have laws that prohibit gun sales to people under the age of 21. And then there are all the as-applied challenges to the federal felon in possession statute involving nonviolent offenses. And it's hard to imagine that the Supreme Court is going to be able to dodge those issues for very long, given the number of cases that are coming up through the lower courts. So I suspect we'll have more to report on that in the future, but not too much to report this year.
Yeah. Well, as we move to the non-discrimination side of things, in the interest of just time and making sure that we hit what I think many of you are probably waiting for, which is Scrimeti, we will talk for a minute about the Ames case. The Ames case was another surprisingly unanimous decision. And in that decision, it was written by Justice Jackson, and I think we've actually not intentionally, but selected a decision that every decision of our decisions, one justice wrote a majority in each of those, which I didn't even know that when we first selected the cases. But Justice Jackson wrote Ames, and it's essentially about reverse discrimination. The question is whether a female employee who was employed by Ohio was making her way up in terms of promotions. She claims she was denied a promotion, and then she was demoted. And in both occasions, she claims that the person that took her job in both instances didn't even apply for the job, but identified as homosexual, and because of that, she claims that they got the job. So she's claiming reverse same-sex discrimination in this case. And the issue is there's a deep circuit split among the circuits about what do you do in a reverse discrimination case where the plaintiff is represented by sort of what the court would call a majority group as opposed to a minority group. And how does the McDonnell-Douglas test play out in that instance. And some of these circuits, like in the Sixth Circuit, were sort of putting a thumb on the scale in saying that if you were part of the majority group, you had to provide background circumstances, in other words, evidence outside of your particular situation that said an employer would actually do something like that they would essentially favor the minority group against the majority group. And thankfully, the court said, no, you know what, under our Constitution, all people are created equal, and under the statute of Title VII, this is nowhere in the text. So in this decision, even Justice Jackson is also a textualist and says, again, when you read the statute, there's no putting your thumb on the scale, essentially, of it. So I think what we're seeing in different publications that are being written about this is some warnings to employers to go back to look at what their policies are, particularly in the DEI context, and how they are using DEI in the employment situation. Now, hopefully they would have already done that, but this case is one more reason that they will be looking at that, as the standards are the same in these situations. In terms of Skrmetti, now we'll get to the Skrmetti decision, which was, I would say, one of the more controversial decisions of the court, and I think one of the more hotly contested issues in the nation right now. And I think it's not just contested in this case, because this case is going to result, or has already resulted in, questions that the court will consider next term as well. So this is a bit of round one, I would say. In the Skrmetti case, it was a 6-3 decision. It was written by the Chief Justice Roberts, and there were strong concurrences on different subjects by both Justice Thomas and Justice Alito. In the case, the question was whether states can essentially pass laws to insist that medical treatments do not continue, and we would call them medical experiments on children who want to identify as the opposite sex, namely meaning the law at issue involved surgeries, puberty blockers, and cross-sex hormones. The court did not deal with the issue of surgeries for procedural reasons, but it did deal with the puberty blockers and cross-sex hormones. And it did go through the science as it went through that. Essentially, it said, first of all, key holdings. This is not discrimination under the Equal Protection Clause based on sex, because the statute doesn't turn on sex. The statute turns on how old the particular person is and that they're minors, and what are you using these drugs for? So you can get testosterone for some uses, but not for others. And that's a pretty traditional way that medicine is approached in the States. So the second thing that was interesting about it is it said, and by the way, Bostock, we're not going to decide if Bostock under Title VII applies in the constitutional context. We're not going there right now. But they then said, as sometimes they do, if we did go there, it would still result in the same thing, because it doesn't turn on sex and the language is different. And it also said, in the majority opinion, it did not really grapple with the issue of transgender status being a suspect class or quasi-suspect class. And that's an argument that we have seen made for decades now in the law, and it keeps coming up in a variety of ways. In this particular case, the court said, we don't need to decide that, again, because we already know what the law turns on: age and diagnosis and medical use of the drugs. So it didn't go there. But Justice Barrett did tease out that a little bit more in her concurrence, where she said, by the way, this is the test for determining a new suspect class. We haven't ever, under this test, found a new suspect class, and we haven't had a new suspect class in 40 years. This is not the time for that. In addition to that, Justice Alito and Justice Thomas also talked about the fact that in terms of suspect class status, one, they don't like Bostock. Bostock is bad, was one of their messages. And Justice Alito said, and even if you applied transgender status here, it doesn't merit heightened scrutiny. So all of this, again, go back to some of the other cases. The level of scrutiny is something that they talk quite a bit about in the case. So that's a quick trip through Skrmetti. I think the Chief Justice Roberts spent significant time on the science behind this, and not only in your legal practice, but just in your life, given the issue that this is in our culture right now. I would encourage you to read this decision, because it does go through the science of our day. And the Department of Justice under the Biden administration said the science is clean. There's a strong consensus that kids are going to kill themselves if they do not get these drugs. And the Chief Justice takes that apart bit by bit. And then Justice Thomas, he just sits in it for a long time and articulates it very well in even more depth. So that's a bit. Tell me what your thoughts are.
It's a fascinating case. I am not sure whether the court was right in its characterization of whether or not this law discriminates. And I think I probably, I think Justice Alito actually, interestingly, essentially agreed with the dissent in that regard. And I think that that's a very close question. But I think that the court resolved it the way it did so that it could avoid deciding whether or not transgender status triggers heightened scrutiny. And I'm not sure the court's going to be able to avoid that question for long, given the cases it has coming up on limitations on women's and girls' sports. And so we'll see if the court gives us more guidance on that next year.
I do think that's an important issue. So the court has granted cert in 2 cases out of West Virginia and Idaho on the women's sports issue, and 27 states have passed laws to protect women's sports. Full disclosure, we're counsel with West Virginia and Idaho in those cases. And I think it will be a different analysis, potentially, because of the way that the lines are drawn in the law. But nonetheless, whether it's rational basis or intermediate scrutiny, there's no question that the physical differences will come to bear in the decision and will be front and center in oral argument. The last thing I would say is another case that's before the court that has to do with these issues before we move on is the Child's case, and that has to do with the gender identity. It also has to do with the science, and it has to do with the First Amendment. And the Child's case involves a licensed counselor in Colorado that has been told under the law, and there are 20 plus states that have laws like these and over 100 local jurisdictions, that say if you have a child that comes to you as a licensed counselor and that child says, I'm confused about my body and I believe that I should identify as the opposite sex, and that counselor tries to help that child learn to live at peace with their bodies, they are breaking the law. And they can potentially, in the end, even lose their license. The court rejected a cert petition a couple years ago on this case and now has granted this case and will be deciding it along with women's sports next term.
Great. Well, we want to leave just a few minutes for questions. So should we lightning round what's left?
Sure.
I think I can do administrative law in a minute. No Loper-Bright cases. The only thing that the Supreme Court did is what it has done since 1935, which is refuse to apply the non-delegation doctrine. It did so in a case called FCC versus Consumers Research, in which parties brought a challenge to the Universal Service Fund, a fund that the FCC uses. It collects these funds from telecommunications providers and uses them for all sorts of purposes, as it turns out, beyond merely providing telecommunications service to underserved areas. And the court, in an opinion written by Justice Kagan, rejected the application of the non-delegation doctrine. This is the notion that Congress has to provide clear guidance when it is delegating legislative power to an agency. I think that the clearest explanation for what was going on here was in Justice Kavanaugh's concurring opinion, when he basically said, in light of the overruling of Chevron and the development of the major questions doctrine, the need for the non-delegation doctrine has been, quote, substantially mitigated, which I think is basically code for there are very few cases where this doctrine would apply where other doctrines would not. We will see if the court gets back into the issue of deference, because lower courts, I think, are really wrestling with how to apply Loper-Bright. Are there circumstances in which Congress has given agencies the discretion to interpret ambiguities, and if so, what does that look like? And I think sooner or later the court is going to have to tackle that.
And of course, the abortion case. That will be our last case for today. In the abortion case, that's the Medina versus Planned Parenthood case. And that also was a 6-3 decision that Justice Gorsuch wrote. In the Medina case, I think the background is important. In Justice Jackson's words, it might be mind-numbingly boring or technical, but nonetheless, it matters deeply. And as lawyers, we know that in many of these decisions, the technical language does matter in a number of areas. This is one. The issue is what the word qualified provider, or what the words qualified provider mean under the Medicaid statute. To go back a little bit, to give you some helpful context, you may remember Center for Medical Progress years ago disclosed some videos and put those videos out about Planned Parenthood potentially negotiating the sale of body parts. That ignited a number of states as well as Congress to start working on defunding Planned Parenthood at the federal and state levels, and 17 plus states actually did so. Planned Parenthood then filed lawsuits and also had clients file lawsuits to tie those decisions up in court. South Carolina was one of those states in 2018, had a law that said we do not fund abortion, use taxpayer funds to fund abortion, and as a result, we are deeming that Planned Parenthood is no longer a qualified provider under our Medicaid statute and would deny them the state portion of those funds as well as potentially the federal portion. So that went up for 6-7 years through the court system, and Governor Henry McMaster stood strong. We had the privilege of representing them at the US Supreme Court, where the court said, especially under the spending clause, Congress does not just create rights without using words that are unmistakably clear that they are creating rights. And this is not unmistakably clear. In fact, it's quite vague, and Justice Gorsuch went through the history, also the text of the statute where it was placed in the overall Medicaid Act, and said this is not clear enough. And so states do have the right to defund Planned Parenthood in their systems. And now we will continue to see, I suspect, well, I know because there's already been a case filed, litigation involving what that means moving forward.
Great. Time for a couple of questions. Reg?
We do have time for maybe 3 questions from the audience, but first, how about a round of applause for our speakers? I haven't seen this much enthusiasm on a stage since Oprah interviewed Tom Cruise in 2005. But we have time for 3 questions. There's some mics scattered about. Who wants to ask the first question? All right, we've got somebody coming over now. Make sure it's on.
Yeah, Ilya Shapiro from the Manhattan Institute. Wonderful presentation. I give enough of these myself, but I learned tons from your remarks as well. I wanted to ask, as the trend that you all noted about the decline of the merits docket and the rise of the emergency docket, is that going to be a permanent thing as we have increased government by executive action? And if so, is there going to come a point where we stop talking about the division between the dockets and it's all just what the Supreme Court does?
I'll offer a couple of observations about this. I don't think that the CASA decision is going to materially affect the emergency docket precisely for the reason that we discussed, which is that if courts can still enter practically broad injunctions based on this putative class action theory, it's going to place exactly the same pressure on the executive branch and therefore on the court. And I think the underlying problem is this structural one, that if policies are no longer being implemented through traditional schoolhouse rock style legislation, you are going to have every incentive for a president's opponents to rush to court as soon as a unilateral action is taken. They will be able to find district courts that are presumptively sympathetic, and this litigation dynamic is going to persist. And I think the second thing I would say is that we have seen the court using aspects of the traditional merits docket for these emergency applications. The court took the CASA case and heard oral argument. It did the same thing in the TikTok case, which was not a case involving presidential action, but yet a case that came up in the context of an emergency application. I suspect that that will continue. And the last thing I would say is that there has been, a lot of writing and some criticism, particularly from commentators on the left, about the fact that the court issues orders with relatively minimal explanation on the emergency docket. I might respectfully submit that if there was a little less separate writing on the merits docket, the court might have a little more energy for some of its emergency cases. But I think the real challenge for the court is that these cases have to be decided quickly. It takes time to get members of the court to agree on reasoning, and sometimes I think it's therefore more expedient for the court to issue these orders without reasoning, even though I think we would all agree that all things being equal, it would be better for the court to provide more of that. And so, this dynamic, I think, is going to continue, and no one should be fooled that it is specific to this administration. I think the next time we see a Democratic administration, we're going to see the same thing in reverse.
Great. We're going to go to the other side of the room. Before we do, where were the business cases this term?
Darned if I know. And this is also something that I think is becoming a multi-year trend. I mean, it is not that long ago that the court was deciding, several securities antitrust patent cases a year. And we're just not seeing it. And I'm frankly at a bit of a loss to offer a unified theory as to why.
Didn't you have a case that was a business case this term?
I did. We're not going to talk about that because it got dismissed. But I think that we're seeing, we saw the court dismiss as improvidently granted 3 business cases this year. And I'm not going to offer a unified theory, but I will say that these cases are often hard. They're often messy because they often have some degree of factual complexity. And they're often cases that don't present the kind of binary circuit conflicts that the court likes to resolve. And so maybe that's part of it, but I think that another part of it, quite frankly, is that we do not have a lot of members of the current court who kind of come from business backgrounds, from backgrounds litigating commercial cases, and maybe that has something to do with it.
Interesting. Over here.
Hi. John Blonigan, Rising 2L at Notre Dame, summer law clerk with New Civil Liberties Alliance. So I wanted to talk a little bit about the last case that you talked about, Medina v. Planned Parenthood. Now, I liked the outcome in that case, and I don't think that that's that unpopular an opinion among present company, but I will say that the posture that it came up with bothered me a bit, and I would have liked something more like the South Carolina shouldn't have had to pass this law because Planned Parenthood wasn't a qualified provider anyway because of the Hyde Amendment, and with the posture of requiring clear statements and statutes to create rights, give private rights of action to plaintiffs, do you think that that holding could actually pose some problems for our movement going forward?
No, I don't necessarily think that it will pose problems for us going forward. I think that it is important that Congress do its job and that it's clear when it means to create a right that it does, that not every benefit is a right. And so in that respect, I think it's a very good holding, and I think it will continue to bear fruit as well. I will say that in our legislative work, for example, in the areas where we're working with states and Congress, we are consistently saying you should include private right of action in some of these and making it very clear, rather than courts reading these things in. And just going back to the comment on the business cases too, I do think it's important to recognize, yes, I'm sure that it is because there are justices on the court that may not be as business-minded, but I also would just bring up the moment that we're living in all of these areas. The last 5 to 6 years, with the way cancel culture has played out, with the extreme issues that are in play, I think is also part of the reason why these cases are coming up, is because the results are so extreme and we're seeing actions in areas that have traditionally been left to families and local governments to work on.
Terrific. I think we don't have any other questions, so we're at the favorite part for me, which is the goodie bag section. And we want to thank our guests. This is the first time we've done the twofer format, and I thought it was spectacular. You guys agree? Terrific. Kristen, we have for you a book not written by AI. It's called The Federalist, or the New Constitution. To Ms. Kristen Waggoner, with sincere gratitude for addressing our Supreme Court Roundup on Thursday, July 24th, 2025. And in the tradition of Miguel Estrada and Paul Clement, we got you a gift from France.
Thank you so much.
Kannon, yours sort of says the same thing. With sincere gratitude for addressing our Supreme Court roundup on Thursday, July 21st, 2025, the Federalist Society. And we also got you a gift from France. Thank you all for coming out today. We're very, very excited about the fall lineup. Hope we'll see you over at our new Italian establishment for luncheons, and we stand adjourned.